Hello and welcome to Working Wise, a podcast created and produced by K&L Gates. Each episode is designed to provide labor and employment updates and compliance tips to lawyers and HR professionals. We hope you enjoy this podcast.
Hi, my name is David Lindsay, and I'm a partner in the Raleigh office of the firm's Labor, Employment, and Workplace Safety Practice. In this podcast, I, along with my colleague Erinn Rigney, an associate in the firm's Chicago office, will discuss employer liability during the COVID-19 pandemic. As we approach the 6-month mark of the pandemic, the question of liability for employee exposure to COVID-19 looms large on employers' minds. This is especially true for essential industries and healthcare facilities that remained in operation during the pandemic, as well as the various non-essential businesses that are now reopening across the country. Employers are trying to navigate the ever-changing regulatory landscape with differing sets of rules and liability standards applying in different parts of the country, and, as of this recording, no uniform federal liability shield. Seemingly daily news of rising COVID-19 infections among healthcare workers and wrongful death lawsuits by family members of workers serve to enhance employers' concerns about legal exposure.
In an effort to make sense of the various claims, this podcast will explore the risks to employers of operating during the COVID-19 pandemic and will focus on workers' compensation and civil liability theories for employee exposure in the workplace. Overall, employers should be aware of the limitations and exceptions under state workers' compensation statutes, minimize the risk of employees' exposure to COVID-19 in the workplace, remain up to date on all federal, state, and local directives regarding COVID-19, and implement workplace guidelines addressing safety in the time of COVID-19. To begin, let's go over the common framework for workers' compensation, which limits available remedies and bypasses more costly civil litigation in resolving coverage disputes.
As background, workers' compensation operates as an employee's exclusive remedy for an injury suffered on the job and generally prevents an employee from recovering both workers' compensation insurance benefits and civil damages. Most states require private employers with one or more employees to carry workers' compensation insurance, and covered employees typically are eligible to receive workers' compensation benefits for injuries or occupational illnesses that arise out of and in the course of employment. To determine whether an injury arises out of and in the course of employment, the general test is whether the employee was exposed to harm, in this case COVID-19, while engaged in some activity for the benefit of the employer. Although many communicable diseases are included under the definition of occupational disease, some states exclude ordinary diseases of life, such as the common cold or flu, from coverage. It is unclear how COVID-19 will be treated, and that treatment could vary by state.
Generally speaking, even if an employer implements all of the proper infection control protocols to protect employees from exposure, if the employee can show that he or she contracted the virus after an exposure peculiar to the work, the employee may have a compensable claim. In addition, employees will have to demonstrate that they were not exposed to COVID-19 outside of the workplace, which may become more difficult as stay-at-home orders are lifted across the country. Due to the contagiousness of COVID-19 and the various modes of transmission, it will be difficult for both employees and employers to identify exactly where an employee contracted the virus. For certain industries, such as healthcare, employees may have an easier time establishing that COVID-19 was peculiar to the employment, especially if the employee was assigned to specific COVID-19 units or patients. However, as states reopen and attempt to return to normal, employers may have more room to argue that employees contracted COVID-19 outside the workplace.
Generally, as mentioned above, workers' compensation is typically the sole and exclusive remedy for employees who suffer injury or contract an occupational disease. However, many states have statutory or common law exceptions to the exclusivity principle, which would allow employees to bring civil lawsuits for workplace injuries and illnesses. Some states provide exceptions for intentional conduct and wrongdoing by a co-employee, allowing a narrow line of on-the-job injury claims to proceed outside the workers' compensation framework. Employees seeking to litigate a claim outside of the workers' compensation forum will need to identify exceptions under the applicable state regulations, statutory authority, or case law, and argue how their injury or illness falls outside of its scope. In these situations, employees likely will claim that employers who failed to adhere to federal or state guidance on maintaining a safe workplace during the pandemic acted intentionally in a manner substantially certain to cause death or harm.
Generally, under most state workers' compensation frameworks, employees need to present some medical evidence that their illness or injury was related to work in order to be eligible for benefits. To satisfy this threshold, they must establish some reasonable factual basis for asserting that the workplace caused their illness or injury. Because COVID-19 can be transmitted in any number of ways outside of the workplace, including exposure to an infected family member, or infection after interaction with a passenger on a transit system, or a fellow shopper in the grocery store, employees may have difficulty tying their diagnosis to the workplace. In light of this heavy burden, many states have taken specific steps to address the impact of COVID-19 on the workplace by modifying the current workers' compensation framework and extending coverage to certain types of employees.
Currently, 15 states have enacted emergency rules, issued executive orders, published official guidance, and even passed legislation to specifically address coverage of COVID-19 under workers' compensation. Of the states that have addressed such issues, almost all have focused on extending coverage to first responders, healthcare workers, and in some cases, other essential employees. However, states have approached the issue of coverage in different ways, from creating a presumption of compensability for certain categories of workers to extending limited benefits to certain workers during periods of quarantine. For example, Missouri passed an emergency rule that created a presumption that first responders infected by or quarantined due to COVID-19 are deemed to have contracted a contagious or communicable occupational disease arising out of and in the course of the performance of their employment. Alaska, Michigan, Minnesota, New Mexico, Utah, and Wisconsin also adopted similar presumptions, which an employer can challenge by providing evidence that the employee was not exposed in the workplace.
2 states have embraced a broad approach to workers' compensation coverage during COVID-19. First, California Governor Gavin Newsom issued an executive order that establishes a rebuttable presumption in workers' compensation claims, presuming that covered workers who are diagnosed with COVID-19 contracted the illness at work, without the employee having to provide any further proof. Although this presumption is rebuttable, meaning that an employer can provide evidence to refute the presumption, it is likely to be a high burden for employers to meet, especially given the wide variety of ways COVID-19 can be transmitted. Further, California extended the presumption to any worker who reported to work outside of the home at the direction of their employer and received a positive test or physician diagnosis, a far broader category of workers than most states. Most recently, Illinois enacted similarly broad legislation, extending a rebuttable presumption not only to first responders, but to any essential workers as defined under the governor's executive order on the pandemic, which would include a broad range of employees who work outside the home, even encompassing home care workers. In addition to the ability to refute the presumption by establishing that an employee contracted COVID-19 outside the workplace, one of the ways Illinois employers can rebut the presumption would be to show compliance to the fullest extent practicable with applicable health and safety practices and guidance. This underscores the importance of implementing effective health and safety protocols that adhere to federal, state, and local guidance.
While workers' compensation likely will serve as the primary avenue for employee illness and injury claims regarding COVID-19, many may pursue and already have begun to pursue different legal theories. For example, employees may allege that an employer failed to provide adequate safety equipment and infection control protocols, endangering their health and safety. In recent months, there have been various lawsuits filed against employers in the retail, manufacturing, and healthcare industries, alleging that employers have created unsafe workplaces and failed to properly protect employees. Family members of deceased employees are also filing wrongful death and survival claims against employers, claiming that the employers required employees to work in unsafe conditions. Further, relatives of employees may attempt to bring derivative claims for personal injury, alleging that they contracted COVID-19 directly from a family member who was exposed in their workplace. As with workers' compensation claims, establishing that the workplace was the point of exposure for both the employee and any infected family members may be difficult for claimants, even if the employee is a healthcare worker or first responder.
As more and more employees continue to serve as essential workers, especially those in healthcare roles, or begin to return to the workplace in non-essential roles, it is likely that there will be a flood of COVID-19 pandemic litigation by employees against their employers. Assuming COVID-19 is a covered occupational disease or injury, most of these claims likely will be barred by applicable workers' compensation statutes, absent egregious employer conduct. Employers should, however, be aware of the limitations and exceptions under the various applicable workers' compensation statutes, which differ from state to state. Further, To minimize the risk of employees' exposure to COVID-19 in the workplace, employers should remain up to date on all federal, state, and local directives regarding COVID-19, implement workplace guidelines addressing safety in the time of COVID-19, and establish or maintain a complaint procedure with a robust anti-retaliation provision. Though such practices will not serve as a complete defense to a workers' compensation claim or a civil lawsuit, administration and enforcement of safety procedures may provide evidence that the employee contracted COVID-19 outside of the workplace. We appreciate you listening to our discussion today. If you would like more information on this subject, please take a look at the Employer Liability Series materials available on the K&L Gates Hub.
Thanks again for listening to Working Wise. New episodes are available for download through iTunes, Google Play, and other podcast applications. If you have any topics you would like to hear about on the next Working Wise podcast, please send them to workingwise@klgates.com.